Am I audible? There's some glitch in the network. Sorry for it. Good morning, everyone. Good morning, Taran. Good morning, Prableen. Good morning, Soumya, Mehul, everyone who is in the class today. Good morning, everyone. Please tell me if I am audible and visible to you. I guess there was some network glitch in the streaming, so I lost the connection, right? And I'm back now. Okay, so I was telling you that I'm coming across some inquiries which are like about the recent judgments of from the years 2020 and 2021. So you really don't have to worry about it at all. Rostrum Legal is providing you the best of the best. The judgment summaries that we cover every alternate week, they are comprised of the recent judgments as well as the landmark judgments of the past years that were relevant and that shall continue to remain relevant for all times to come. So you really don't have to worry about it at all. We are providing you the best of the best. Okay, most of the important judgments from the criminal law as well as the constitutional law as well as the civil law and the commercial laws also, they are being covered in these judgment summaries. So and most of the things, like many of you ask me that besides this, what you are doing, what you are telling us and what you are conveying to us is very good, but besides this, are we supposed to do something beyond than this? It would be really good if you try to do as much as you can. Okay, there's no limit. When you sit and when you study, there's no limit how much knowledge you can acquire more and more. So basically, you really don't have to worry about it at all. Okay, I'm okay, I guess everything is fine, everything is going fine. Okay, now it is really important to cover cases like Shreya Singhal versus Union of India. Shreya Singhal versus Union of India is that one important case which has become a landmark case in the discourse of the constitutional law as well as in the discourse of the information technology, because freedom of speech and expression have freedom of speech and expression has widened its ambit to an extent which is beyond our imagination now. Okay, earlier the freedom of speech and expression primarily used to be restricted to the print media, but when the technology expanded beyond, okay, when the technology expanded, when we developed radios, when we developed telephones, when we developed advertisements, when we developed the means of communication, and there was literally a boost, there was literally a very vigorous boost in the field of digital revolution. No other revolution in the world or in the universe was so much vigorous and was so much healthy and robust as the digital revolution was, and it is still the most robust one. So the entire digital revolution has widened the ambit of the scope of freedom of speech and expression contained under Article 19(1)(a) of the Constitution. Earlier, we used to read about the newspapers, then we used to read about the telephonic conversations, then we started reading about the ambit of the radios. Okay, then we started reading about the ambit of the televisions, the serials, the films, the cinematography. And then now we are talking about the information technology, because we are living in an era of social media, of the latest technology. We use the very recent technology to convey our messages. WhatsApp is something which was extremely unimaginable by the people who lived in the past. They could not even think that something called WhatsApp, something called Facebook, something called Instagram will be developed in the future, and it will be very easy for the people to communicate with the other person who is sitting on the other side of the world on a mere click of a button. So this is such a such a boon for us to have communications so handy. It has become so handy. So this has also widened the freedom of speech and expression. It hardly takes any time for an individual to convey his thoughts throughout the world. If he is a celebrated personality, he can have his Twitter account to tweet anything he likes. Okay, he can share his political views. He can share what's going on in Russia and Ukraine. You can share your views on the political ongoings in the country. You can comment on the foreign policy of India. You can do you can comment on anything. So this is very important to be reckoned with, or to be considered, or to be taken into account. Okay, so the freedom of speech and expression. Now, as we developed this technology, as we developed social media, as we developed the Android technology, it really became pertinent for the state to regulate this. Earlier, freedom of speech and expression was regulated, and it will continue to be regulated, because unless it is not regulated by some reasonable restrictions over its head, then otherwise every person whosoever is possessed with this right would become an unruly horse, especially the media. So we really have to put some reasonable restrictions on the freedom of speech and expression. This is really important for every state, for every civilized state, to have reasonable restrictions. I am not against it under Article 19(2) of the Constitution. When we developed this technology, when we developed social media platforms to convey our thoughts, it really became pertinent for the state to regulate them under the guise of reasonable restrictions. And there was a legislation called the Information Technology Act of 2000. Okay, which restricted and prohibited certain comments to be made and certain status to be updated of a certain nature. Okay, but the question arose, how far these kinds of restrictions on the floating of our thoughts are good enough in the eyes of the Constitution, in the eyes of the ambit of Article 19(1)(a) of the Constitution of India. So Shreya Singhal versus Union of India is that one case which is very landmark, which is really needs to be pondered upon by every person whosoever is intrigued to know about the intricacies, about the nitties and gritties of the freedom of speech and expression. Okay, this is Shreya Singhal versus Union of India. A writ petition criminal number 167 of 2012 was filed under Article 32 of the Constitution of India. You can see the date, 24th March 2015. Who was on the bench? Justice Sheila Meshwar and Justice R.F. Nariman. Now the facts of the case. The petitioner filed a public interest litigation. This was a public interest litigation suit under Article 32 of the Constitution of India. I have already told you, because when we discuss some things, it is also very good to discuss certain extra things regarding it, because examinations like CLAT, they ask you to, they need you to be very versatile and to have knowledge from all around the field. So when we talk about public interest litigation, I have already told you what is public interest litigation. This concept of PIL is not mentioned under the Constitution. What we have is just Article 32 having 5 writs for the redressal of the individual grievances rather than the grievances of the masses at large. But we borrowed this concept, the Supreme Court borrowed this concept from the American judicial system, wherein it becomes very easy and very feasible to get the grievances of the masses redressed at a larger scale. Okay, at a very large scale. Like redressal is very important when the individual rights or when the fundamental rights of the masses are violated at large. Then the public interest litigation comes into play. Justice P.N. Bhagwati was very instrumental in introducing this concept of public interest litigation within the ambit of Article 32. So this is one of them, because when we talk about the fundamental rights of the masses at large, or in the interest of the general public, we often use this public interest litigation as a means or as an instrument to get a right redressed. So the petitioner filed a public interest writ suit under Article 32 of the Constitution of India. You already know this. This is the writ jurisdiction of the Supreme Court, and you can approach the Supreme Court under this article directly, asking the Supreme Court to declare Section 66A, 69A, and 79 of the Information Technology Act ultra virus to the Indian Constitution. What was so problematic about with Section 66A and 69A and 79 of the IT Act? The only thing was that Section 66A, 69A, and 79 has created certain obstructions or hassles in the floating of your ideas, unrestrictedly. So they were challenged. The petition claimed that the wording of these impugned laws or impugned provision of this law are broad and vague. The petitioner also stated that the goal of these clauses is to abuse it recklessly, and thus falls outside the scope of Article 14, 19(1)(a) and 21 of the Indian Constitution. Menacing, offensive, annoyance, inconvenience, obstruction, danger, and insult are all terms that are not defined in any act. Okay, now these these sections like Section 66, the impugned sections, we are talking about the impugned sections. What are they? Section 66A, Section 69A, and 79 of the Information Technology Act. Okay, they use these words like you cannot float something which is menacing, you cannot write something which is menacing, you cannot say something which is offensive, which is annoying, which is inconvenience to a section, which is inconvenient to a section of the population, which creates obstruction, or which apprehends danger, or which makes a calibrated insult of a section of the population or an individual. Now these are all terms which are not defined in any act. So these terms, the menace, the offense, the annoyance, these terms can be used by the state, or can be misused by the state rather, in imposing unreasonable restrictions under the guise of reasonable restrictions. So the state really need to define these kinds of words called offensive. What is annoying? Something may be annoying for an individual, and the same thing may not be annoying for the other individual. If the perceptions regarding these words may differ from person to person or from an individual to individual, so it is really necessary for the state to define them or put them into fixed parameters. It was really important. So as a result, it is more vulnerable to undesired abuse. Aside from that, or beside from that, the distinction drawn between citizens and netizens of the country was deemed arbitrary and in violation of Article 19(1)(a) of the Indian Constitution, which guarantees freedom of expression. This is really good. Citizens and netizens are two different entities. Citizens are the general people, the general nagrik of the desh, of the country, and netizens are a section out of the citizens which are completely dwelling upon the use of internet. Okay. Most of the citizens today do not use net, like a section of the citizens, or you can say the very old people we have today that hardly use the internet. They have nothing to do with it. They hardly can understand that there is something called virtual world also that exists today. So netizen, it was really good to define the citizens and netizens, and if the act, these sections have differentiated between the citizens and netizens of the country. Citizens and netizens of the country, like netizens are the people. If these words like offense, annoyance, inconvenience, obstruction are making a calibrated concern for the netizens only and not talking about the citizens, so this was held to be arbitrary and in violation of Article 19(1)(a) of the Constitution, which is a general provision for the citizens and not particularly for the netizens. It was claimed that the distinction allows police personnel the right to detain netizens for remarks that can also be expressed by ordinary people of the country. So this is what democracy is all about. The depth, gravity, and intensity of the democracy is measured on the ambit on the depth, intensity, and gravity of the freedom of speech and expression which is given by it to the citizens of the country. Okay, the more you are free to express your thought, the more democratic your country is. This is the bedrock of democracy. If you are not given a chance to put your thoughts across, or to put your views and opinions across, or to opine anything, then it could be anything but democracy. So as a result, the fundamental right to equality enshrined under Article 14 of the Indian Constitution is violated. So if you are making a calibrated concern or a targeted or calculated concern for the netizens of the country, you shouldn't create a difference or distinguish between the citizens and netizens, because it is about the general welfare of the people. And most importantly, if you are giving the police personnel to right to detain anyone just because he has put his points across, or he has expressed his political thought or a social thought, then it is a complete and a blatant violation of the democratic principles of speech and expression, and it shouldn't be the the concern. So really it is important to have define these words very distinctly, very clearly, very expressly, or put them into fixed parameters, or rather blur this differentiation between the citizens and netizens. You really can't differentiate between the two. We are talking about the freedom of speech and expression, about the general citizens of the country. There's nothing called netizens. It is just our virtual imagination. So you really can't do that. Okay, so it was deemed arbitrary and in violation of Article 19(1)(a) of the Constitution. Besides this, if you are giving a privilege to a section of the population, so this amounts to the violation of Article 14 of the Indian Constitution, also principles of equality. The state shall not deny to any person equality before law or the equal protection of laws. There's nothing called reasonable classification, which is based on intelligible differentia, and the classification also does not have an object which has a rational nexus with the means to be employed to achieve that object. Neither there is any object or a need to have such reasonable classification. The classification is also not reasonable because it is not based on intelligible differentia. So there's nothing exists regarding the justification of it under Article 14 of the Constitution of India. Okay, so are you getting my point? Now what was the issue? Whether Section 66A, 69A and 79 of the Information Technology Act are constitutionally valid. The question was, like, are they valid or not? Because if you put them, you will find many of the words that are used here, that the general language of these sections, which is in sharp contrast with the principles of the Constitution under Article 19(1)(a) and 14 of Article 19(1)(a) and 14. So it's really important to make this as an issue and discuss this and moot this. Section 66A of the Information Technology Act, Section 69A of the Information Technology Act, Section 79 of the Information Technology Act, Article 14 of the Constitution of India, Article 19(1)(a) of the Constitution of India, and obviously Article 21 of the Constitution of India. Article 21, automatically comes into play everywhere because it is an umbrella provision which covers almost everything. Everything under this umbrella, there's everything under this umbrella. Everything under the sun is within the shadow of Article 21, or under the shadow of Article 21 of the Constitution of India. Now, arguments of the petitioner. The petitioner who challenged the constitutionality of these provisions, what he really contended: the right to free speech and expression guaranteed by Article 19(1)(a) of the Indian Constitution is waived by Section 66A of the Information Technology Act of 2000, and it is not covered by Article 19's reasonable categorization of Clause 2. We have a list of, categorical reasonable restrictions within under Article 19. Repeat the last point, Jazban. Okay, the last point is that if you contend about the validity of these provisions under Article 14 of the Constitution of India. So under Article 14, what it is? It is about the equality principles. Okay, if you really want to justify the classification between the citizens and the netizens, you really need to prove that there is a need for such classification. The classification is reasonable and it is based on intelligible differentia. There is an object for this classification to be achieved, and the object has a reasonable or a rational nexus with the means employed to achieve that objective. Okay, so all these things hardly exist here. Okay, so this differentiation between the citizens and the netizens, there is a particularly the police personnel have been given this this authority over the netizens to get them detained for simply expressing any thought which they deem as annoying or inconvenient or obstructing or anything which is given here, or insulting or anything which is given here. So this is really not justified. Have you understood? Baat hotam. Okay. Now, the right to free speech and expression guaranteed by Article 19(1)(a) of the Indian Constitution is waived by Section 66(a) of the Information Technology Act of 2000, and it is not covered by Article 19's reasonable categorization of Clause 2. What is there under Article 19's reasonable classification? I have already told you many times before that there are 8 reasonable restrictions, or 8 restrictions under Article 19(2) which are reasonable. Reasonable in the sense, when I say reasonable, they are justified in order to protect any media house or any individual any entity, whoever possesses this freedom of speech and expression, to become an unruly horse. No fundamental right is absolute, not even your right under Article 21 of the Constitution is absolute. Your life and your personal liberty can also be taken away if procedure established by law is duly followed. So what you need simply is to understand that fundamental rights are not absolute, and hence your freedom of speech and expression is also not absolute, and you need to have some restrictions which are reasonable as per the facts and circumstances of each case. And you really need those reasonable restrictions are the parameters for anything which restricts freedom of speech and expression. If you really want to restrict a particular freedom of speech and expression, you really need to prove this, or you really need to get it in consonance or in conformity with all the reasonable restrictions which are contained under Article 19(2) of the Constitution. So this categorization under Clause 2 of Article 19 is the parameter for judging a restriction's reasonability. Okay. The petitioner further stated that acts of generating annoyance, impatience or vexation are not covered by Article 19(2) of the Indian Constitution. Okay, there's nothing called annoyance, there's nothing called impatience, there's nothing called vexation. If I'm getting irritated with someone's opinion, do you think my irritation is my own personal temperament? For example, you can take my example. I am not a tech savvy person, and I really, I'm not on social media, I'm not on Facebook, I'm not on Instagram. I just only use WhatsApp for official purposes and for, to get with the members of my family connected. That's it. I have a limited social circle, and I am connection with those only. So I really don't have any account. So you can see me on LinkedIn because it's a professional platform. But I am not on Facebook. I'm not on social media because my personal temperament is that I hardly pay any heed or attention to what other people think and what they are doing and what they are eating and where they are going and where they are roaming about. I am simply of the concern, like, if something is annoying me on social media, that is my problem. If my thoughts are annoying you, that is your problem. Your individual annoyance, your individual impatience, or a very small section of the population gets annoyed on something which is unreasonable. Okay, which is unreasonable, or which is, there's something, any political thought, any social thought may be very, vexating for a section of the population. That simply doesn't mean that the thought is not good, or you can't really say this in the public discourse generally. So things like annoyance, things like impatience, things like vexation, this is not defined under Article 19(2) of the Constitution of India. So we really need to give it a thought again. So this annoyance, impatience, what do you think? There are reasonable restrictions in the name of the security of the state, in the name of public order, in the name of decency and morality, in the name of sovereignty and integrity of India, in the name of foreign relations in relations with the foreign state. You have restrictions regarding defamation. Okay, now these are the things which are really at a very large scale. These are important. These are really important at a very large scale. Okay, now this large scale restrictions are important. If something is annoying you, then that is your problem. The state cannot make it a reasonable restrictions because Mr. X is getting impatient, or Mr. X is getting irritated or annoyed because of something. So something is annoying, something which is impatient, something which is vexating cannot be the reasonable restriction for anything. So these words are absolutely uncalled for in a democracy which gives you freedom of speech and expression. Section 66A was also not covered by Article 19(2) of the Constitution. Section 66A was also argued to be unclear because it does not define a number of concepts. The terms can be interpreted in a wide range of ways, making them vulnerable to exploitation by executive agencies. Like a police officer, he might think that, for example, a police officer who is in the cyber cell, if he comes across any post which is very irritating for him personally, then his personal temperament might come in between, and he might use it as a ground for as a ground of annoyance or as a ground of vexation, and he can get the person detained. Okay, now his personal temperament shouldn't come in between. Somebody's annoyance, somebody's irritation, somebody's vexation, somebody's impatience is not the state's concern. What is of the state's concern are the general interest of the nation. Whatever is in violation of the general interest of the country should be the reasonable restrictions, and not somebody's choice can come in between. Okay, the classification of charging just netizens under Section 66A of the IT Act has no discernible distinction. What netizens are? Like any person who is using a WhatsApp, or who is simply using a WhatsApp like me. I'm not using internet, or I'm not using social media, but I'm using internet because I have to take your class. I'm using WhatsApp because I want to connect with my family members every time. I want to stay connected with my friends, and I really want to share my PDF doc with my students like I do every morning. So, there is a wide range of people who use who use the internet in a different way for different purposes. Some are very limited, some are without, limitless. So we really can't have a very distinct distinction, very distinct differentiation between the citizens and netizens of the country. So this is not discernible at all. What netizens are, what citizens are, you really can't create a difference. I have already told you in Baat Jazbaat Tum, she asked me about repeating this point. I've already told you there's no reasonable classification. We are making a calibrated attack out of a section of the population whom we tend to call netizens. But this classification is not reasonable at all. You really can't point out of such a whole population, this is a netizen and this is a citizen. This is really so stupid, and so this is really such a vague thing. Somebody who is into a virtual world has become a netizen without any reasonability and without any intelligible differentiation. We have created this classification without any need. Okay. So that is not acceptable. So these were the contentions of the petitioners. I guess these grounds are clear to you today. I guess this is very clear to you. Please tell me if things are clear to you. Clear. Okay, Nikhil says most people will fall under netizens then. Yes, every single person today is a netizen. Hardly a very minuscule population would come out to be the only citizens. But this classification, I don't think, even that was the contention of the petitioner, that this classification is not at all reasonable. Okay, so most of this it's clear to all of you. Most of you, quite good number of you are clear with this point. Now, arguments of the respondent. The respondent argued that it is the legislature's responsibility to satisfy people's needs, and that the judiciary will only intervene if a statute is in violation of Part 3 of the Indian Constitution. Furthermore, the respondent claimed that there is a presumption that the statute in question is intra-vires to it. So the respondent argued that it is the legislature's responsibility to satisfy people's need. Now the respondent says, like, the respondent was trying to justify it. Union of India was trying to justify its own creation. Its own creation was like the legislation. So the Union of India was trying to justify that it is the legislator's responsibility to satisfy the people's need, and it was the people's need to put some reasonable restrictions under the garb of Article 92. Also on the platforms like information technology platforms like social media, and we really needed sections like 66A, 69A and 79 of the information technology that control the floating of thoughts across the social media discourse. So it was really important, and that the judiciary will only intervene if a statute is in violation of Part 3 of the Constitution. Furthermore, the respondent claimed that there is a presumption that the statute in question is intra-vires to it. Okay, statute in question is intra-vires to it means, furthermore, the respondent claimed that there is a presumption that the statute in question is intra-vires to it. Intra-vires means, like, ultra-vires ka opposite hai intra-vires. Intra-vires means that it is in conformity or it is in consonance with Part 3 of the Indian Constitution. Judiciary can only intervene wherein any law, any provision or any section of any law is in violation of is in violation of Part 3 of the Indian Constitution, which contains fundamental rights. So judiciary should not intervene and should try to understand the legislature's responsibility to satisfy people's need, and it was really a need to have such a regulation and control. Okay. The court of law has the power to interpret the law in a way that makes it justly enforceable while also reading down the complexities of the rules. So the court of law has the power to interpret the law in a way that makes it justly enforceable while also reading down the complexities of the rules. If there are complexities involved in any law or in any rule, all those complexities should be read down. Okay, and yes. There is a presumption of constitutionality. Yes, I guess most of you must have done moot courts in your law colleges. Moot courts, we developed this argument of presumption of constitutionality there, that the first argument that we put in favor of any legislation which is challenged to be unconstitutional, that is that there is a presumption of constitutionality unless it is proven to be unconstitutional expressly by the court. So there is presumption of constitutionality. Yes, that is also one of the very reasonable arguments, Jazba, that there is a presumption of constitutionality, and then the court of law has the power to interpret the law in a way that makes it justly enforceable while also reading down the complexities of the rules. The executive's abuse of legislation cannot be the primary basis for declaring a law ultra-vires to the Indian Constitution. Okay, executive's abuse of legislation. Like, if the legislature has made a law which was needed, the respondent's arguments, I'm telling you the respondent's arguments. Okay. I'm telling to you about the arguments of the respondent, that the legislature felt the need, the legislator made a law. The legislature made a law. Okay, made a law. Then, if executive wing of the government happens to violate any such law made by the legislature, then that misuse by the executive cannot be the primary basis for declaring a law ultra vires of the Indian Constitution. Its misuse should be protected in some other manner. The executive should be taken control of, or the government should try, or the legislature should try to control the movement of the executives in regarding any misuse of any law. But really, the law itself cannot be ultra vires to the Indian Constitution simply because it is being misused by the executive. Simply because if the police or the any entity like that happens to find anything which is annoying or insulting, then that simply is insulting, which is personally hurting a policeman, for example, then that cannot be the sole basis for declaring a law as ultra vires to the Indian Constitution. You should find some other argument to do that, but this simply can't be the one. In the law, okay, in the law, broad terms are employed to defend citizens' rights from those who infringe on them using this medium. Like this is a very general argument. Like this was expected to be there, and anyone who would be in place of this respondent would have argued this, that in the law, broad items are employed to defend citizens' rights from those who infringe on them using this medium. This is really good. Okay, you have to defend citizens' rights from those who infringe on them using this medium. Okay, there are very broad terms which are used. Okay, the creative liberty, freedom of speech and expression, bedrock of democracy. These are such heavy phrases, heavy words which are used for really granting an individual or an entity the freedom of speech and expression. And you really can't, you really can't provide a limitless freedom of speech and expression. You will have to put some reasonable restriction. The vagueness of the law is not a reason to declare a piece of legislation ultra vires to the Indian Constitution, especially when it is regarded qualified and just in other ways. The vagueness of the law is not a reason to declare a piece of legislation ultra vires to the Indian Constitution, especially when it is regarded qualified and just in other ways. Okay? Now, simply because something is vague, something is undefined. Nikhil Garg wants me to repeat the second argument. What is the second argument? See, the quote of this, I guess the second bullet point, Nikhil. Now, simply because something is vague, something is undefined. Nikhil Garg wants me to repeat the second argument. What is the second argument? See, the quote of this, I guess the second bullet point, Nikhil. Okay, Nikhil, okay. So, the court of law has the power to interpret the law in a way that makes it justly enforceable. Okay, what the court of law is supposed to do, you have to interpret the law that makes it justly enforceable, that the law should be enforceable in a very just manner. That's it. Okay, and if there are some complexities or some complications involved in the law, they should be read down or they should be discarded, and it should be simple and clear. The law should be interpreted in a simple and clear manner, and it should be justly enforceable on the people. That's it. You shouldn't go into the fact that vagueness is involved or something undefined is there mentioned. You just interpret it in a way which is just, which is reasonable. That's it. And if you find any complications, just discard them away. That's it. That is the job of the judiciary, which the respondent is trying to contend in its argument. Okay. Now we were reading the judgment. The court in its judgment held that Section 66 of the IT Act was repealed in its entirety because it violated Article 19(1)(a) of the Indian Constitution, and was not protected under Article 19(1)(a) of the Indian Constitution. See, I must tell you one thing very, very important here. Even the restrictions which are reasonable, which are said to be reasonable under Article 19(2) of the Constitution, they are like, you cannot have a fixed definition of each of them, or you cannot put them into fixed parameters. You cannot put them into fixed parameters, I must tell you. Since 1950, since the enforcement of the Constitution, every single reasonable restriction has been interpreted in a different way, every time, in every case. Sometimes some restriction was held to be very reasonable, while in most of the cases all the reasonable restrictions were held to be not justified. Okay, so it completely depends on the facts and circumstances of each case, that in what context every single reasonable restriction has to be interpreted. The context changes every time. The context changes every time. For example, the case with Bandit Queen was that in the initial stages of its release. Hello? Hello? Am I audible now? Hello? Hello? I guess the stream is working now. I guess the stream is working now. Please tell me. Okay, then I'm resuming my lecture. So the court in its judgment held that Section 66 of the IT Act was repealed in its entirety because it violated Article 19(1)(a) of the Indian Constitution and was not protected under Article 19(1)(a) of the Indian Constitution. The Constitution of India was held intra vires to Section 69A and the Information Technology Procedure and Safeguards for Interception, Monitoring and Decryption of Information Rules 2009. Okay, the validity of Section 79 was upheld subject to the reading down of Section 79(3)(b) of the IT Act. The Apex Court of India also knocked down Section 118D of the Kerala Police Act. Okay. Now the judgment is like it has in the judgment portion they have really brought certain other provisions also, but here in this case of Shreya Singhal versus Union of India, we are specifically talking about the validity and constitutionality of Section 66A of the Information Technology Act 2000. Okay, Section 66A, which restricted the free flow of information or free flow of ideas and thoughts, be it political or social or moral or economic or financial or anything or of any nature, can be freely floated on various social media platforms, and Section 66A's restrictions were held to be in violation of Article 19(1)(a) of the Indian Constitution. All the contentions of the petitioner were reasonably bought by the Supreme Court, and all the contentions of the respondents were with due respect kept aside by the Supreme Court. So the whole in the case of Shreya Singhal versus Union of India is about the validity of Section 66A of the Information Technology Act. Okay. Besides this, if you have not understood anything, you are most welcome to ask and discuss me. And I'm really sorry for the technical glitch because this is something beyond my control. I have like so many connections around me, and I'm trying to connect it with in the every possible manner. Some glitch happened, and I don't know how it happens, and I'm really sorry for it. Now you are most welcome with your queries now. Yes, Ultra Bookish. Case is completed. I have discussed the contentions of the petitioner, the contentions of the respondent, as well as the judgment. The judgment is very long, really very long judgment, but we really can't go line by line. We can only read the gist of it and what was held there. That's it. Okay. Anything else, any question regarding this case or anything else that you want to ask besides this? Sure, Ultra Bookish. Nikhil is asking me, "Ki what should we primarily remember for the exam?" I mean, what you have to remember. See, what you are being taught, what you are being feeded by Rostrum Legal is a complete package of the CLAT exam. You really need to, you hardly need to look beyond this. Okay, but so far as my field is concerned, like my field is like I'm taking your legal current affairs. Perhaps I will start taking your environmental law by next week. So far as current affairs and your recent judgment summaries are concerned and landmark judgments are concerned, you really can do as much as you can. Because I'm trying to cover all the important judgments of the recent past, of the last 2 years especially, and also all the landmark judgments. So, and all the important current issues also, the recent legislations, the recent amendments also. So, how should we study the case laws? That's what I'm telling you. You can do as much as you can beyond than this. I always say there's nothing called enough in the current affairs. Something or the other is always happening even when I'm talking to you right now. So you really, it's very difficult to keep tabs on every single thing which is happening in the field of current legal affairs, especially legal affairs, because in some way or the other, every state government or every in the central government or the Supreme Court tries to introduce something new every time. Every new dimension comes into picture every day. So it's really difficult to keep tabs on everything. But as I always say, that you really have to, look beyond this and do as much as you can. You create your own limit regarding preparations as per your own capability. Don't see what others are doing. Just try to compete with yourself. You really don't need to look at the other person, how much he's studying and how is he studying. It's your way, it's your style, and it's completely your capacity that will decide your credit and your potential. So you compete, try to compete with yourself. Compete with yourself means if you have done something today, try to do something better than this tomorrow. And by every day you have to grow. That's it. If you are going to compete with yourself, then definitely you're going to be successful. If you're going to look at others, definitely you will be doomed. So you really don't need to compare yourself with the other person. Try to find out and decipher your own capabilities, set your own limits, try to grow every day. If you have something done today, try to do something better and more than this tomorrow, and the day after tomorrow, more and more. You have to grow on a day-to-day basis. That's it. Okay, so that's all you have to do. Ultra Bookish is asking, is this relevant for judicial exam? Every single case law, every single recent judgment is important for judicial exams also. So just go for it. Don't think if it is good or not good. You only have to concern yourself with reading and keeping yourself updated and posted every second. That's it. Okay, so I guess there are no more questions regarding the case. So can I sign off now? This is all, they are already uploaded and shared on the WhatsApp groups every day, Ultra Bookish. Or you can Google it. The Google will give you a long list of judgments that you won't be able to cover them all. Every judgment that is being taught to you is important, Ultra Bookish. You can't really sift them now. How long you are going to sift the important judgments out of a list of important judgments itself? If you have a list of important judgments, they all are important. Don't try to be over selective. Okay? Don't try to be over selective. Any other question regarding the case? So I'm signing off now, and hope to meet tomorrow with another case law. Okay, till then, all the very best. Bye bye.